a request for reconsideration on CPC 251-15. I think this will be the first official appeal that we have heard as a body. So I'm just going to go over the rules real quickly that are published in our rules. Anyone who has filed a civilian complaint who is dissatisfied with the findings or recommendations approved by the POB can request consideration. In this case, Mr. Aracene was not happy and he requested reconsideration under one of the bases where that's allowed. Those are that a policy was misapplied, that the findings or recommendations were arbitrary, capricious, or constituted an abuse of discretion, or that the findings, recommendations were not consistent with the record and evidence. In this case, it was granted, and we're going to be hearing that now. Okay. The SOP in question is 2-12E2B5, I think. Do you have that to read to us, Mr. Harness? We're not finding it here.
Chairman, I did not bring the SOPs with me. I did not.
If you take a look at the information I gave you, Director Harness outlined that SOP in the findings letter, which I believe is Exhibit E.
Okay.
The SOP says that an officer is not allowed to go into district court in uniform. And there are two exemptions, one being that it's a preliminary hearing and one being that it's an emergency. So it's either or both. The pleadings that I'm trying to get into evidence or onto the record will clarify the situation as far as it being a preliminary hearing.
Do either of you have an objection to allowing this in? Mr. Baker?
Chair Mohr, I reviewed it, and I don't believe that it's a problem. Clarifications would be, if it's admitted for the purpose of clarifying what type of proceeding was there and detail related to the statement that was already underlying the investigation, I don't see a reason for the court to not accept that.
Okay, it's not being, it's not in for the truth of any particular matter, so we're just showing the scheduling. So that's fine, Mr. Aracene, it's in.
Good, thank you very much.
Keep going.
Now let's talk. I want to look at the record concerning this being a preliminary hearing that would grant Officer G an exemption to the SOP as outlined by Director Harness on page 2 of Exhibit A. And that goes back to the findings letter. Going back to Exhibit F on page 11, starting at line 16, Investigator McDermott asked Ms. Holtz if this hearing could be considered by any definition as being preliminary. This conversation continues to page 13, line 15. Ms. Holtz produces no factual evidence, but instead simply states that in her opinion, this is a preliminary hearing. Anyone with experience, as I myself have, of going through a TRO hearing will tell you you have one shot at persuading the judge to grant or not to grant a TRO. And the record here bears this out in Exhibit J, wherein the court denied the TRO hearing 3 days after the hearing on December 17th, 2015. There was no secondary hearing for the parties to bring in additional evidence before the judge made her final decision to deny the plaintiff's legally submitted request for the TRO. The truth is this was not a preliminary hearing in any sense of the word, and the preponderance of the evidence shows this. Officer G cannot be afforded the preliminary hearing exemption under this SOP because in this CPC, it simply does not apply.
I believe the designation as put forth by City Attorney Holtz that this was a preliminary hearing because it was for a temporary restraining order. The next would be for a permanent restraining order, and that's why it is preliminary.
Okay, Mr. Aracene, you have 5 more minutes, sir.
Okay, I just want to speak to a couple of things that the director said. The first thing he said was that this was a thorough and fair investigation. I gave him 7 witnesses, they interviewed 1. That's thorough, all right, and I don't believe that's fair. As to the hearing not being preliminary, the record clearly shows that there was no secondary hearing before the judge made a decision. TRO hearings are a one-shot deal. You go in there and you present your case, the opposing party presents their case, and the judge makes a decision. There is no secondary hearing on a TRO. What he's discussing is a permanent restraining order, which is a completely different animal. A temporary restraining order is exactly that. It's temporary, and it lasts, I believe, 5 to 10 days.
Yeah, and for me, and the board members are free to make their own opinion, I think a preliminary hearing is a preliminary hearing, and it has a specific legal definition, and that's what it is. So the real question before us is, was it an emergency? So to me, a preliminary hearing is a real thing, and this, TRO is not a preliminary hearing. A preliminary hearing is a preliminary hearing. Am I leaving anything out? Yeah, Mr. Harrison.
It's perfectly fine with me if you take all the time you like. If you don't want to make a decision here tonight, I'm perfectly fine with you waiting until next month.
Okay. I think we'd like to, do it all in one shot while we remember what we're talking about, but thank you.
Well, I'm not sure if Mr. Cruz has what he needs in front of him or not. So that's all I was going to say.
Are there any board members that would like to take a brief recess to review the materials? Because we can absolutely do that.
I really don't know how good that's going to do me. You spoke a lot, and I wasn't able to keep up with you. I'm sorry.
I can give you what I have. I have a complete set of these records. Would you like that?
Just prepared for you. Have a good evening.
My personal feeling is that we've spent more than enough time on this. I'd rather we make a decision.
I concur.
You want to make a motion?
Chairman,
Mr. Waits.
I make a motion that we retain the original findings as presented by the CPOA.
Second.
We have a motion and a second to affirm our original decision to go with the findings of the CPOA in this matter. So the POB may affirm, modify, or change our original findings. The POB may make further recommendations to the chief regarding the findings or the discipline. In this case, that doesn't apply. Decision on appeal shall be made by the majority of the board members present. I don't see where it says whether there's a letter or anything that comes out of our decision, but, Mr. Harrison is here, I don't think he needs a letter, what we said.
We asked the chief to give us letters. I think we should write them down, whatever we decide.
I think that's fine. We can do a letter officially outlining what our decision is. Any other discussion? Okay. So we have a motion and a second to affirm our original decision in this case and go with the CPOA's original findings, Director Harness's original findings. All those in favor, please say yes.
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 Any opposed?
No.
Anyone wish to abstain? Okay. Those are our findings. Thank you, Mr. A preliminary hearing is a real thing, and this, TRO is not a preliminary hearing. A preliminary hearing is a preliminary hearing. You're kidding, right?